The Kansas primary elections take place August 4th. Not only will Sunflower State voters make their party nominations official for statewide and local offices, they'll also be asked to consider a fundamental change in the way justices are selected for the Kansas Supreme Court, moving away from a so-called nominating commission to direct elections by the people of Kansas. First, some history. From statehood to the late 1950s, Kansas voters elected members of the state's highest court. That changed after a political scandal called the Kansas Triple Play. Governor Fred Hall had lost a re-election bid in November of 1956, and Chief Justice William Smith was resigning from the court. Hall devised a plan to replace Smith by resigning the governorship and elevating Lieutenant Governor John McQuish to the office for less than 2 weeks. In that short time, McQuish appointed Hall to the Supreme Court. Outrage over the scheme resulted in the legislature passing a resolution calling for a statewide constitutional amendment vote they hoped would remove politics from the process. Voters passed the reform, which created a judicial nominating commission whose job it is to vet potential nominees for the court when a vacancy occurs. The panel gives 3 names to whomever is serving as governor at the time, and a new justice is chosen from among the 3 finalists.
The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
So why is there now a move to go back to direct elections for the Supreme Court? Kansas lawmakers adopted a resolution to make the justices stand for election again out of a belief the court needs more public accountability. Decisions in recent years on school funding, abortion rights, and other issues, some say, run counter to the Kansas Constitution and the will of the people. Groups like the Kansas Bar Association and the ACLU of Kansas are voicing their support for the status quo. They claim it ensures judicial integrity, but Brittany Jones with Kansas Family Voice believes the current system is preferred by the attorneys because they control it.
What makes Kansas so unique in this model is that we allow that nominating commission to be controlled by the Kansas Bar. So there are 9 people on the committee, and 5 of them are attorneys that are directly and only elected by the Kansas Bar.
Jones asserts there is a lack of accountability in the current setup.
It's a very insider game. You have to kind of be friends with the commission and friends with the other attorneys in order to get appointed. And so it really doesn't open it up to anyone besides someone who's an insider with the Bar Association.
She says the political left has used their influence over the years to tilt the court's decisions their direction, even to the point that justice retirements have become politically motivated.
They won't retire during a Republican governor. Governor Sam Brownback only got 1 justice on the Supreme Court, and that was only because President Obama appointed the former justice to the 10th Circuit, making an opening on the court.
Kansas Family Voice is encouraging a yes vote on the amendment. Jones says defenders of the system as it is are determined to protect their political power.
The opposition is saying we don't want the courts to be bought. Don't make them political. But to think that they're not political now is just to have your head buried in the sand.
A yes vote rewrites the Kansas Constitution to require members of the state Supreme Court to be elected to 6-year terms and doing away with the Judicial Nominating Commission. Making judges run for the position could reduce judicial activism on the court and keep them more accountable to the people of the state.
Order in the court.
Those in opposition argue the justices are already accountable for their rulings through a retention vote. However, the Kansas Family Voice president believes a vote to retain the judge lacks the proper scrutiny necessary to determine if retention is warranted.
A retention election happens at the end of a 6-year term. Half of the time, people don't even know how they voted. They don't know how. They didn't have any cases that really told anyone anything that they needed to know. And these justices don't really go around and meet people. They're not really accountable to the people. And if by chance we did happen to not retain one of them, It goes back to the same process of that lawyer-controlled commission and the governor picking that got that justice in that seat in the first place.
Some proposed amendments to the state constitution in the past have been confusing to voters, and Jones says she's confident that that will not be the case this time when Kansans head to the polls next month.
Whether you're a Republican, a Democrat, or independent, it will be at the end of your ballot. For an independent, this is probably all that will be on their ballot. So I encourage you to make sure you read to the end. Those who drafted the amendment tried to make it as simple as possible. About 4 sentences, very clear, very straightforward.
Should voters approve the change, Kansas would join the ranks of 22 other states that select members of their state Supreme Courts this way. Above all, both sides of the issue say it's important to vote. Kansans have until July 14th to register if they are not, or to update their registration if they've moved since the last election. Reporting for Great Plains Christian Radio, I'm Delvin Kinser.